Hey, good morning, everyone. This is Juanita, Cape Fear Family Law. We're just going to do a case update with you guys real quick. We just got a case that came down from the Court of Appeals. It's an unpublished opinion, so I wanted to give you a little update. There's some important points in it that I think y'all should know. I'm going to probably destroy this last name, and I apologize in advance. I believe it's Wrubluski, Wrubluski. So this is a case that came out of Onslow County, North Carolina, with Judge Henry Stevens IV. Our local hero, Mr. J. Albert Clyburn, was the appellate attorney representing the plaintiff in this case. Quick facts, just to give you some idea where we're headed here. You got parties that got married in 97. They were married for 17 years. Separated in 2014. During the marriage, they had 4 kids. And when they got divorced, their absolute divorce went through in 2015, which makes sense, the year and the day law here in North Carolina. So in 2014, they entered into a memorandum of judgment and a parenting agreement. Just quickly, a memorandum of judgment is just a very sort of consent order that we write sometimes in court that resolves a case before a trial. So this is without a hearing. And in that memorandum of judgment, he agreed to pay $2,500 for family support. And that's going to be important later. So remember what I just said, $2,500 for family support. Parties then get divorced. And in 2016, I'm sorry, back up again. In that memorandum and the parenting agreement, mom is awarded primary custody of all 4 of the children. So fast forward now to 2016. 2 of the children come and live with dad. Dad unilaterally decides to reduce his reduce his support from $2,500 a month to $1,250, which makes sense. It's 2 kids, half the support obligation. It's also important to note that around the same time, Dad is medically retired from the military, and he goes from making, I believe the order says about almost $8,000 a month to just under $4,000 a month, though that'll also be important here in a minute. So now you have dad having 2 children, mom having 2 children. Dad unilaterally reduces his child support obligation. And now we are years after divorce. And that's important to note because people think these things can happen quickly, and often they don't. This case spent years in court coming to resolutions. Mom files a motion to show cause against dad, saying that dad is in contempt of court by reducing his obligation to $1,250 unilaterally. Dad does file a motion to modify that obligation, but in the pendency, he reduced it without a court order. Those are the general facts, and let's move now into what the court found. So I think that there's a lot of important things that come out of this ruling, but I'm going to start with sort of what I thought were the top 3. So let's start with the family support obligation. Remember, I told you at the very beginning we were going to come back to why it was labeled family support. And I think this is a good thing for us lawyers to remember. Be clear. Be very, very clear in our orders. Because labeling it as family support and not delineating what was set for post-separation support or alimony versus what was set for child support came back and bit this gentleman quite a bit. He self-reduced. The court came back and said, you don't have the right to do that. You need a court order in order to reduce the child support obligation or a support obligation, regardless of whether you have an oral agreement or not, regardless of whether there was a change in custody. And it's important to note here as well, nobody disagreed that 2 of the children came and moved in with dad. The issue was, did he have the right to self-reduce? And the court said very clearly he did not. So what the court also said, and this is a little confusing, and I think that there's going to be some follow-up on this in future cases, but court also said no arrearages accrue and there's no past due amounts. But that doesn't give you the right to self-reduce. You can still be found in contempt because you're still in violation of a court order. Until that order is modified by the court, you have to abide by it. Talking a little bit about the self-reduction issue, remember that this case has been through multiple hearings at this point. You've had dad filing a motion to modify his support. You've got mom filing motions to show cause, or motion to hold him in contempt by alleging he didn't follow his support. And in the interim, the court does enter an order reducing his amount of payments. Mom was also found to be cohabitating, which makes her barred from receiving any post-separation support or alimony, which we will come back to here in just a few minutes. So the important thing to note here about self-reduction is simply just don't do it. So the court ruled that even if the parties had an agreement, if they had an oral agreement that 2 of the children would reside with dad, no arrearages would accrue and no past due would accrue, but you're still in contempt of court. So one doesn't go with the other. Yes, you can agree to reduce your support obligation, you can agree to a custody arrangement, but without a court order, you cannot self-reduce your child support. Okay, so let's talk a little bit about the self-reduction issue. Like we said, 2 children in 2016 moved in with dad. Dad filed a motion asking for his child support obligation to be modified. Dad self-reduced his obligation from $2,500 in family support down to $1,250, which makes sense, it's half. Mom files a motion to hold him in contempt of court by saying, you had no right to do that. So the court comes in and says, Mom is right. So even though 2 of the children did come in and live with you, and even though on its face you would think, well, that makes sense, he cut it in half, he has half the kids, the court said that's not enough. We have a court order and you're violating that court order, therefore you are in contempt of court. That doesn't mean, though, that he should be accruing arrears and he should be accruing past due, which come with their own penalties. It simply says, absent a court order, you have to keep paying what the court ordered amount is, or you can and likely will be held in contempt. So what to get out of all that is, guys, if women, ladies, men, if you're ordered to pay child support, pay it until the court orders that it can change or is terminated. The next thing I think that was important in this case, the father in this case, the husband, was medically retired from the military, and his income substantially decreased, which was part, in addition to him having 2 of the children, was part of why he asked for a reduction in his support obligation. He simply no longer had the ability to pay at the rate he was paying. Interesting, though, is that the court made a very specific finding here. I think this is important to remember, that these court orders are forever. So this is forever in this file. And they found that this man acted without heart, conscience, or foresight by reducing his payment. He appealed that finding of fact, and the court said it stays because there's evidence to support it. The reason I think, and this is me reading into it a little bit, but I think one of the reasons for that is that this man knew what his obligation or his new money would be from the VA, from his disability benefits, and he simply withheld that information from the court. The court found that there was a letter that outlined what his payment was versus what it would be on under his medical retirement, his disability, and he simply didn't choose to give that to the court. So what to get from that, everyone, is don't hide things from the court. Don't hide things from your lawyer. Don't hide things at all. Don't lie. We can deal with what we know. We can present facts in light most favorable for our clients. We can argue cases, but if you hide that information from the judge, you will likely be punished for doing so. So no misleading, no misdirection, just be honest. Final thing I'll say about this case, attorneys pay close attention. I think this is a big one for us, particularly. We are often asked to ask for attorney's fees, and we often believe that we are correct in asking for attorney's fees and that they should be awarded. And this court made some very clear findings for us to follow for awards of attorney's fees. They gave us 5 factors that must be in our findings of fact in order for the court to order attorney's fees. So this means we have to present evidence on these issues, and they have to make their way to the final order. Do not just put it in your affidavit of attorney's fees. That's not part of the findings of fact. So findings of fact would be, number 1, that the party seeking attorney's fees does not have the ability to pay and to defray the cost of litigation. We almost always see those in orders. I don't think that's news to any of us, but just make sure it's in the finding. Number 2 is that the party seeking attorney's fees proceeded in good faith in the lawsuit in itself. Make sure that's in your findings. We don't always see that in there. Number 3, and I thought this was probably the most interesting, we have to advocate our skill level as attorneys. We have to put in the findings of fact the level of the lawyer's skill to sort of prove to the court that our client rightfully paid us the money that they paid us. Make sure you put a finding of fact about the lawyer's skill. Number 4, you have to put a finding of fact as to the lawyer's hourly rate. Again, you guys, our affidavits of attorney's fees are simply not enough under this order. Final one, number 5 for this, is you have to have the nature and the scope of the legal services provided in your findings of fact. Often don't see that either. So again, just kind of a quick overview. Our top 5 things that attorneys have to be putting as finding of fact. Number 1, that the party seeking attorney's fees does not have the ability to defray the cost for the lawsuit. Number 2, that the party seeking attorney's fees acted in good faith in proceeding in the lawsuit. Number 3, the level of the attorney's skill. Number 4, the lawyer's hourly rate. And number 5, the nature and the scope of the legal services provided. Guys, it's an interesting case. I hope I didn't destroy the name too much. Read it if you can find if you need it. We can send you a copy. Again, it's an unpublished opinion. I hate to do the name justice again, but Wrubluski versus Wrubluski out of Onslow County. Judge Henry Stevens IV was the original trial court judge. Thanks, you guys. Don't forget to like, share, follow us, and comment if you like. We'll talk to you soon.